I'll call to order the Subcommittee on Communications and Technology and thank our witnesses for being here for this first of what will be many hearings as we look to update the Communications Act. Few sectors of our economy are equal to the communications and technology sector when it comes to innovation, investment in the American economy, and job creation. In these tough economic times, we as policymakers should be committed to fostering this critical sector of the economy. Yet the laws that regulate the industry are outdated at best, and some are affirmatively damaging. This is why Chairman Upton and I, along with members of this subcommittee, have decided to undertake the difficult task of updating the Communications Act of 1934. In the 8 decades since its passage, Congresses have come and gone. Some have even made substantial, though targeted, changes to the law. But none have undertaken to rethink the Act for the environment of convergence and innovation in which we live today. It's time for our laws to reflect our modern technological landscape, one grounded in the networks and services of our past and driven by our IP and mobile future. Just yesterday, the D.C. Circuit issued its decision in the net neutrality case, striking down the rules ordered by the Federal Communications Commission. I, for one, was pleased to see the court remove the government from the business of making management judgments and give providers the freedom to make decisions that are pro-competitive and pro-consumer. While this decision benefits consumers and providers alike by keeping the Internet free from government interference, the rationale highlights the ongoing confusion regarding regulation of different services. This is yet another example of why it's vital that we take a hard look at the laws in this space and reconcile them with the realities of technology. The answer is not to subject new technology to outdated regulations, but rather to craft laws appropriate to innovative services and platforms. As we embark on this effort, it should come as no surprise that I'm focused on ensuring that we engage in a transparent and collaborative process, not just with our colleagues here in the Congress, but also with the many stakeholders outside of these halls. What we want is a dialogue. Last week, the committee released the first of what will be a series of white papers seeking input from the public, and I hope that interested parties will take the opportunity to make their voices heard to us. Today's witnesses provide a unique and valuable perspective on the Communications Act. As chairman of the agency tasked with carrying out Congress's will and implementing the Act, the 4 witnesses today have had a front row seat to witness the Act in the real world, to see where it works and where it doesn't. These chairmen have varied experiences and viewpoints that in many ways represent the evolution of modern communications. When Chairman Wiley led the agency, telephone service was a government-regulated monopoly. Consumers got their news from broadcast television and print newspapers, and the Internet was still years away. 16 years later, when Reed Hundt took the reins, the Internet was coming into full force and mobility was beginning to take off. Chairman Powell's tenure saw the convergence of services towards the bundled offerings we see today, as well as the deployment of broadband to Americans. And in the 4 years since Michael Kopp served as acting chairman, there have been dramatic changes to the way we communicate and the technology that powers our lives. For example, the title of today's hearing contains a hashtag. Twitter, then with no vowels in its name, had yet to be discovered at South by Southwest. Neither we nor the august panel before us can predict the future and what technological changes it will bring. But by learning the lessons of the past, we can do our best to create a legal and regulatory environment that will foster innovation and competition, encourage consumer choice, and optimum services. So again, I want to thank you to our witnesses for this impressive panel. We look forward to hearing your testimony, and we appreciate your public service. With that, I would yield to the Vice Chair of the Subcommittee, Mr. Latta, for any opening comments he may have.
Well, thank you very much, Mr. Chairman, and thank you very much to our panel of distinguished witnesses for testifying before us today. I appreciate you all being here. Since 1966, we have witnessed an unprecedented technological evolution in the communications industry. The rapid emergence of new and innovative technologies has fostered increased investment throughout the industry in the development of a vibrant, competitive communications marketplace. As we move into the future, it is important to examine the Communications Act to ensure that our public policy continues to encourage this kind of growth and innovation that is essential to fueling our economy. Reforms to current law should reflect the technology we enjoy today and be able to adapt to the technology of tomorrow without further government intervention. Our efforts should be dedicated to ensure that the laws governing the communications marketplace do not stifle current and future investment, innovation, economic growth, and consumer choice in this dynamic and converging digital age of communications. I look forward to the testimony from our witnesses today, and again, Mr. Chairman, I thank you very much for holding this hearing.
Thank the gentleman for his comments. Now turn to the gentlelady from California, Ms. Eshoo, the ranking member of the subcommittee, for her opening comments. Good morning.
Thank you, Mr. Chairman, and good morning to you, to all of the members, and the warmest welcome to each of the witnesses that are at the table. Your combined public service is really stands as a hallmark of devoted service to our country, but also to move the country forward in one of its most important economic sectors. So welcome to you. It's wonderful to see all of you at the same time at the table. With news of the court's net neutrality decision, today's hearing, I think, is a timely opportunity to hear from each one of you who have led the expert agency, the FCC, and combined it represents over 4 decades of service. That is nothing short of extraordinary. And each of you have had a hand in really, I think, changing our nation's communications and technology landscape. So not only kudos to you, thank you to you, but a recognition of what each one of you accomplished. When Congress passed the Telecommunications Act of 1996, it was my second term in Congress, my first term on the committee, and there were just 11 references to the Internet, the word Internet, and only 1 mention of broadband across a 128-page bill. Many proponents of updating the Act have cited this as evidence that the Act is outdated and unable to keep up with changes in technology. But as Chairman Wheeler affirmed last week, the Communications Act continues to provide the FCC with ample authority to exercise its role in this new environment. The Court's decision yesterday, I believe, furthers this argument by upholding the FCC's existing authority to oversee broadband services. And I think that's very important for consumers across the country. I make these points not to discourage the subcommittee's review of the Act. I join with the chairman to review this. I think that it's a worthy exercise. But rather, we need to ensure that we know what problems we're trying to fix before undertaking a multi-year examination that include hearings, stakeholder meetings, white papers, and the such. Since the 96 Act was enacted, hundreds of new entrants have emerged, and more than $1.2 trillion has been invested by U.S. telecommunications companies. I want this success story to be an unending one, and I think that is the goal of everyone on this wonderful subcommittee. So to that end, my goal throughout the subcommittee's review will be to see more competition, greater consumer choice, and more innovation. I am so proud, as the chairman was making his opening remarks, that so much of this has been born in my congressional district. And so innovation, innovation, innovation. And these goals were embedded in the 96 Act, and they remain just as important today. At the same time, our process of examining the Communications Act should not derail, in my view, a more immediate update of our video laws, a view shared by a majority of the witnesses at a September subcommittee hearing. Recurring TV blackouts, coupled with the rising cost of broadcast television programming with limited choice, has left consumers frustrated and looking to Congress and the FCC for answers. I believe that working together on a bipartisan basis, we can make this happen in 2014. So, Chairman Walden, thank you for holding today's hearing on the Communications Act. I welcome the review, and I look forward to hearing the unique insights from the top experts from our country who have given so much in terms of their leadership in leading the expert agency And with that, 34 seconds to yield to Congresswoman Matsui.
Thank you, Ranking Member, and I want to welcome all the former chairmen. We welcome you here for your ideas and experience that provide a basis for discussions moving forward. As technology evolves, I believe it's important that we consider appropriate updates to the Communications Act that with goals to promote competition and innovation in the marketplace. To that point, I am pleased that yesterday the D.C. Circuit affirmed the FCC's authority to oversee broadband services. In my opinion, that was the crux of the debate, and the FCC's argument prevailed on the question of authority over broadband. The FCC will need to exert its authority to ensure now that all Americans have access to a free and open Internet. A competitive marketplace with checks and balances will fare well for all Americans. I look forward to the hearing today, and I yield back the balance of my time.
Gentlelady yields back the balance of her time. Chair now recognizes the distinguished member from Michigan, the chairman of the full committee, Mr. Upton, for opening comments.
Well, thank you, Mr. Chairman. Last month, you and I announced our plans for a comprehensive update to the Communications Act of 1934. And the changes in technology since the last update in '96 have been dramatic, and existing laws have failed to keep pace with the vibrant and dynamic telecommunication industry. Communications and technology sectors have consistently been areas of American leadership, innovation, and job creation, certainly. But the Communications Act is showing its age, and our continued international leadership is indeed at stake. Yesterday's net neutrality decision, while a victory for consumers and the economy, illustrates the uncertainty flowing from the current statutory scheme and the need for this action. It's time to revamp these laws to reflect the new competitive landscape and changing consumer expectations. And as we begin the open process leading to a Comm Act update, we are looking for input. Yes, we are, from all of the stakeholders in the communications and technology world. Where better to start than with our distinguished panel of former leaders of the FCC. These leaders served during diverse times in the evolution of the communication sector, and they've seen the market operate under the strong hand of the U.S. government and the challenges with them divorcing the government from its heavy regulation of the communications sector from times before. They've seen cable grow from its days as a struggling startup. They've seen satellite services succeed in bringing competition to the video market and fail to find success as a competitor to mobile phone service. And they've seen the Internet grow from a DoD project to a tool for research universities, and now as the commercial economic force that we know today. Throughout the many nuanced iterations of the Communications Act, today's witnesses have firsthand seen the Act at its finest, and also when its inability to keep pace with technological innovation has impacted those vital economic issues. So I want to thank the witnesses for taking their time to share their experiences with us. We value indeed their expertise and welcome their thoughts on how we can ensure the Communications Act fosters our communications and technology sectors well into this century. And I yield the balance of my time to the Vice Chair.
Thank you, Mr. Chairman. And if I had my iPhone in my hand, I would hit retweet for everything that he has just said. We do appreciate that you all are here. We do want to take advantage of the perspective that you have had. Think about what has happened in the past 17 years since '96 and the changes that we have seen, not only in how we communicate, but the rapidity of those communications and entertainment and how we access that, how we take it with us, how we consume it. So we know that the pace of change means that we have to be very judicious and careful as we look at a rewrite. We know that there are issues that are going to come on the plate that we're going to have to discuss also as we look at not only the telecom rewrite, but at the use of the virtual space, privacy, data security, the way the virtual marketplace is used, and the way our constituents want to have a toolbox to protect, as I call it, their virtual you online. So we appreciate your time, your willingness to be with us this morning, and I yield back to the chairman of the committee.
Yield back.
Did gentleman from Texas, Mr. Barton, want to use some of that time? It is.
Thank you. Thank you, Mr. Chairman. I've served on this committee since 19 1986. I've served with 3 of the 4 former chairmen. Mr. Wiley preceded me. We've had some agreements, we've had some disagreements, so it's good to have all 4 of you gentlemen here today. When I was chairman of the full committee back in 1996, my committee introduced a bill we call the COPE bill, the Communication Opportunity Promotion Enhancement Act of 2006. It dealt with national franchising, net neutrality, public educational and governmental access, E911, and what we now call VoIP. It passed this committee 42 to 12 and passed the House 321 to 101, but it didn't come up for a vote in the Senate. I voted for the Telecommunications Act of 96 and the Cable Act of 92, and I hope this year to get to vote for another major bill that comes from the leadership of Mr. Upton, Mr. Walden, Mr. Waxman, and Ms. Eshoo. This is a good thing to be doing, and we're going to get some good information from you gentlemen, and we appreciate you being here.
Gentleman's time's expired. Appreciate his comments. We'll now go to the former chairman of the committee, Mr. Waxman, for opening comments.
Thank you very much, Mr. Chairman. I appreciate your convening this morning's hearing and launching the subcommittee's examination of potential updates to the Communications Act. And I want to thank our distinguished panel for being here to help us think through these ideas. And I think I've been in Congress during the time that all of you have been the heads of the FCC. Technology has changed at a blistering pace since the enactment of the 1996 Telecommunications Act 18 years ago. The communications and technology industries are a thriving sector of our economy. As broadband plays an increasingly central role in the daily life of our nation, having a strong Federal Communications Commission to oversee its successful growth is more critical than ever. Yesterday, the D.C. Court affirmed what never should have been in question. The FCC is the expert agency charged by Congress to oversee broadband networks. In doing so, the Court reaffirmed that the FCC has broad, flexible authority to regulate in the broadband and digital age. However, while the Court recognized the FCC's jurisdiction, it also overturned the specific rules the Commission had adopted in the Open Internet Order. I believe the FCC now has an opportunity as well as a duty to exercise the authority the Court recognized yesterday and reinstate the no blocking and non-discrimination rules. An open Internet is critical to the continuing growth of this economic sector. The Internet is a vibrant platform for commerce, innovation, and free speech. Having enforceable open Internet rules of the road means that consumers are in control of their experience online. I'm pleased that Chairman Wheeler has stated his intention to expeditiously adopt a new set of rules following the Court's guidance, and I look forward to working with the Chairman and my colleagues in Congress to make sure these pro-consumer, pro-competition policies will continue to guide the expansion of broadband services. This subcommittee is now embarking on a journey to update the Communications Act, and regardless of the advancements in network architecture or transmission protocol, the principles of competition and consumer protection remain as sound today as they were in 1934. I know Chairman Wheeler recognizes the importance of these values, and the action of the FCC that plans to take later this month to initiate technology transitions trials reflects that. I look forward to hearing from our witnesses about what Congress can do to help the FCC meet the challenges of the broadband and digital age. Thank you, Mr. Chairman. I want to yield the balance of my time to Mr. Doyle.
Thank you, Mr. Waxman. Mr. Chairman, thank you for holding this hearing, and thank you to this distinguished panel. It's good to see all of you here in front of the committee. I just want to briefly concur with Mr. Waxman in light of yesterday's decision by the D.C. Circuit that I want to encourage Chairman Wheeler to work quickly to ensure that the Internet remains an open platform for innovation, competition, and economic growth, which the FCC now clearly has the authority to do. I look forward to working with the Commission and the stakeholders to put in place a robust framework that sustains an open Internet Mr. Waxman, I thank you for your courtesy, and I would yield back to you if someone else needs some more time.
Would like a minute? If not, I yield it back, Mr. Chairman.
Gentleman yields back the balance of his time. We'll proceed now to our distinguished panel of witnesses and begin with Chairman Richard Wiley, who was nominated by President Nixon and served as chairman of the Federal Communications Commission from 1970 to 1977. As chairman for most of the 70s, Chairman Wiley's tenure at the commission predates many of the major changes in the communications sector. Chairman, we're glad to have you here today. Pull that microphone up close, turn it on, and you're good to go. Thank you for being here. You'll need to push the button on the microphone there. And one time.
Thank you very much, Chairman Walden, Ranking Member Eshoo, and other subcommittee members. Thank you for the invitation to testify today. While I know it's not going to be self-evident due to my youthful appearance, I've been involved for nearly 45 years in federal telecommunications policy. And from my own standpoint, what has occurred during that period is simply amazing. When I was at the FCC in the 1970s, the average American enjoyed just 3 broadcast television stations and 1 local and long-distance telephone provider, and the Department of Defense had just begun to explore a revolutionary computer project known as ARPANET. But today, our citizens have access to hundreds of video channels delivered by countless providers and transmission technologies, dozens of voice and text services, numerous wireline and wireless companies, and of course, ARPANET has morphed into the Internet, which has become a universal medium of communications. Interestingly, the bulk of this stunning technological metamorphosis has emerged since the 1996 Telecommunications Act was passed. That legislation significantly altered the rules governing virtually every aspect of communications. The Act's purpose was as simple in theory as it was complex in implementation. That is, to provide for a pro-competitive, deregulatory national policy framework designed to accelerate the deployment of advanced services and open all telecom markets to competition. To this end, the statute sought to eliminate cross-platform barriers and to encourage competition among service suppliers previously treated as monopolies or oligopolies. Now, to the credit of the drafters, the 1996 Act helped to bring about the vibrant competition that consumers enjoy today in a variety of communication sectors, be it voice, data, or video. Whether delivered by twisted pair, coaxial cable, optical fiber, or the electromagnetic spectrum, myriad providers today are offering their customers suites of advanced services in a marketplace that really could not have been imagined 18 years ago. In my view, where the statute and indeed FCC implementation has succeeded is when a lighter regulatory touch has been applied to markets, such as mobile and information services. The result has been that these sectors have thrived. For example, in the robustly competitive wireless marketplace, there are now more wireless subscriber connections than the population of the United States. Just think of that. And mobile broadband has spawned an entirely new industry, mobile apps, one that is estimated to employ more than 500,000 developers and related jobs and contributes billions to the economy. A similar success story is unfolding in the delivery of digital content, where seemingly unlimited video streaming websites have developed to compete against traditional MVPDs, offering an eagerly waiting public new ways to consume video. This marketplace, I would suggest, is emerging because of innovation and competition and not because of government regulation. Conversely, where the government has been less effective in maintaining highly restrictive regulations on traditional industries, like, for example, wireline telephony and broadcasting. The end result has been to disadvantage these sectors, even though they may be providing services that are often equivalent to those offered by their less regulated competitors. In the developing IP-centric world, all types of providers should be able to market all kinds of services, employing the same computer-oriented language that defines digital communications. And yet, the 1996 Act continues to regulate communications markets differently based on the conduit used to reach the customer as well as the geographic location where traffic originates and terminates. Now, the underlying problem is not a failure of congressional or FCC vision. Instead, the reality is that the government has great difficulty in writing laws or promulgating regulations that can keep pace with advancing technology, and especially so in a dynamic and ever-changing industry like communications. Thus, I would suggest that the objective of a statutory rewrite should not be to legislate premised on the current state of the marketplace or even on predictions of what it may look like in the future. Instead, Congress may want to consider a flexible and technologically neutral framework that will be capable of adapting to technical invention and innovation, whatever that may prove to be. In this regard, let me close by setting forth a few principles that might guide the drafting of a new statute. First, the industry silos embedded in the 1996 Act should be abolished, and instead functionally equivalent services should be treated in the same manner regardless of who provides them or how they are delivered to consumers. Second, the traditional dichotomy between interstate and intrastate services should be eliminated because regulatory classifications based on geographical endpoints no longer make sense in an IP environment. Third, legislation should be focused on maintaining consumer protection and public safety regulations. Conversely, economic regulations should be considered in the case of non-competitive markets or in the event of demonstrated market failure. And fourth, new regulations should be instituted with a lighter touch, as I said, accompanied by sunset provisions so that the rationale for continued government intervention can be reviewed on a regular basis. Thank you once again for the opportunity to testify.
Chairman Wiley, thank you very much for your learned comments. We appreciate your counsel. We'll go now to Chairman Reed Hunt, who was nominated by President Clinton and served as chairman of the FCC from 1993 to 1997. Chairman Hunt's tenure at the Commission saw the passage of the Omnibus Budget Reconciliation of 93, which granted the Commission the authority to auction spectrum licenses, and the Telecommunications Act of 96. So, Chairman Hunt, thanks for joining us today. We look forward to your comments as well.
Thank you, Chairman Walden. Thank you for inviting me. A good morning to Ranking Member Eshoo and to all the other members of this distinguished committee. I'm very proud that many of you have become lifelong friends, and it's a pleasure to be here with you. I also want to thank the D.C. Circuit for giving me a flashback to law school so that I was late last night scrambling to read the key case right before this class. I have a feeling I'm not the only person here who did that, but I also want to note I didn't have any staff or classmates, so I apologize if I haven't read it correctly, but I thought that I would throw away my remarks and, for whatever it's worth, offer you my reading of the case. In my view, the D.C. Circuit has written, first, a very, very well-reasoned and very important case. There's no question that this reflects that circuit's experience in these topic areas and that they've brought that experience to bear in a bipartisan way to express a view about how the United States ought to grant the authority to create the legal culture that governs broadband. What have they said? I believe the court has vindicated the wisdom of Congress in the 1996 Act. Specifically, the court has said that when Congress in that act, in Section 706, conveyed to its expert agency the, quote, authority to enact measures encouraging the deployment of broadband infrastructure, unquote. In doing that, according to the D.C. Circuit, Congress said to the FCC, you will be our instrument for creating a flexible and a supple legal culture that will change over time as the market changes and as technology changes. but that can always be used to protect competition, to protect consumers, and fundamentally, to make sure that absolutely everybody in America is participating in the common medium of the Internet, and that absolutely everybody in America is able to use it to publish their views and to review all the views of everyone else. Not all those words are in this decision, but almost all those words are actually in this decision. Section 1706, of course, is just one part of the 1996 Act, but I know I don't have to remind many of the members here, maybe I don't have to remind any of the members here, that was passed by a very large bipartisan vote in the Senate and in the House. We all were, those of us who were in public service then, remember being in the Library of Congress when President Clinton, the Democratic president, passed this law that was passed by a Senate controlled by the Republicans and a House controlled by the Republicans, and all came together and said, we have a common vision, and that is that there will be networks. We did not know, technically speaking, what they would all exactly look like, but that there would be networks that would connect all of us to each other and to all of the resources of information that in fact would be utilized for entrepreneurship, for innovation, and for learning. And I have to say, this is what's happened. Now, no one here thinks the government built these networks. No one thinks the FCC built these networks. But everyone should know that the legal culture that was created by Congress and its expert agency, through the terms of Republican and Democratic chairs, the legal culture is the legal culture that is regarded all around the world as the absolute best legal culture for governing the Internet. Any one of us knows 12 things that we think should be done differently, or maybe 24, but we ought to recognize, just for a little while, that we as a country should pat our government on the back and say, for the last 20 years, the legal culture that's been created that has governed the Internet has really created the best possible environment for innovation, for entrepreneurship, for consumers. That's what's actually happened, and this court has said, and that law still exists. This court has said already Congress has enacted the law that gives the FCC the authority to protect competition and consumers. And that authority, according to this court, lies in Section 1706. And the court also said that Congress can, that the FCC can, if it choose, classify broadband as a common carrier. It could use either of these methods, it could use one of these methods, but it can accomplish the goals that are stated in the Act and that have repeatedly been restated by this Congress. The only thing the court said is, if you're going to pass rules that look like common carrier rules and you're going to classify broadband as an information service, then you're going to be creating a contradiction that we won't permit. You can't call it an information service and then pass rules that look like common carrier rules, because if it quacks like a duck, it's a duck. So that's why it was sent back. I read a lot of articles that said that this was a victory for Verizon. This is a victory for Congress. If it was a victory for Verizon, it was a Pyrrhic victory. It was the most perfect example of a Pyrrhic victory since Pyrrhus. So I just want to compliment this Congress on passing a supple law that has worked well, and that this court has just said still will permit you to achieve your goals through the expert agency. Thank you.
Thank you, Chairman Hunt. We appreciate your comments and your staying up all night to cram for our hearing. Now turn to Chairman Michael Powell, who was nominated by George W. Bush and served as chairman of the FCC from 2001 to 2005. During Mr. Powell's chairmanship, they saw a significant increase in the deployment of broadband to American homes, as well as convergence of services toward the development of broadband, toward the bundles of services that are common today, among many other things. Chairman Powell, thank you for joining us today, and please go ahead.
Thank you, Mr. Chairman. And as a former chairman, I'm happy to be sitting around with a bunch of these other chairmen offering as best we can our historic perspectives on how to prudently go about rewriting the Act, should that be your intention. And I'm pleased to be with Ranking Member Eshoo again and all the distinguished members of the committee. I think it goes without saying, and all of us will say it in different ways, that the world has changed quite radically from 20 years ago in terms of markets and services. But don't ask us, ask your kids. ask them to name 3 broadcast networks, if you will, ask them to do without the internet for a week, and for God's sakes, ask them to put their phone down at dinner and see what reaction you get. I think you'll be convinced. That transformation has taken place largely because of an enormous revolution in network architecture in the form of the internet, which has unleashed a form of intermodal competition that heretofore wasn't really possible. And it's really introduced an exciting world, and we should remember gave birth to a host of companies and opportunities that never were envisioned before. The companies that aren't here, Google, Facebook, Amazon, eBay, Twitter, Instagram, you name it, all able to be born and flourish because of this transformation. I would say that any consideration of the Act should start with not only cataloging its ills, but cataloging its successes, much as Reed was alluding to. I think it's really important to note that over this period, we have seen the most stunning amount of investment in infrastructure and architecture that we've ever seen. We have reached 90% of Americans faster than any other technology in world history. Innovation and growth have continued at exponential rates, with broadband increasing over 19 times just in the last decade, doubling, basically increasing about 50% annually. That's a stunning achievement and something we should make sure we keep going. So I think, being guided by the old maxim of do no harm is an important cautionary tale. As I thought about how you might think about architecting a new regime, I'm guided by the idea of the internet itself, which is the fundamental principle of simplicity as a design principle. It has been a very, very powerful one in the internet, and I think it offers some guidance in this space as well. So I'd like to, toward that end, offer, I'm going to see Mr. Wiley's 4 principles and do them 3 better and offer you 7 as briefly as I can. The first is we've heard a lot about innovation. I do think the principal goal of the government should be to nurture that innovation. This is the kind of fomenting change we have never been able to harness as fully as we are today. Innovation has allowed us to bring completely new products and services and network changes to the market. It's created a form of creative destruction that keeps the market energetic and keeps monopoly in check. And I think it's created new kinds of transparency for the American consumer through crowdsourcing and visibility. And we should study the conditions that go into innovation to make sure we harness them. I think 3 are critical. Innovations really do require freer markets. In a market that moves at Moore's law speed, the pace of adaptation, transformation, and change are incredibly fast. And there needs to be a constant and intense dialogue between producers and consumers. We should be careful to protect that. Innovation requires risk-taking, and as we know, most new ventures fail. There has to be room in government policy for failure. There has to be room in government policy for encouraging taking those risks. And innovation requires stability. Investing more than $1 trillion, as Congressman Eshoo was talking about earlier, since 1996, is stunning, but it requires a stable regulatory environment to provide that uncertainty, because if investment slows, innovation will slow with it. The second rule of simplicity, I think, is once you've created a lighter regulatory environment by trying to pursue the maxim of less is more, organize it better. We certainly have heard about the challenges of silos and buckets. Clearly that had its place in another time when these technologies, applications, and type of companies were deeply intertwined. We're not able to provide alternative services in other spaces. That day has moved on, and we certainly crave a more unified, integrated kind of legal regime that doesn't make those sorts of distinctions. In fact, as I've heard mentioned today, I think yesterday's court decision and the multi-year debate on net neutrality that illustrates the almost tortuous challenges sometimes of addressing a modern circumstancing using provisions of last century's rules. I think there's certainly widespread agreement on core principles around an open internet. Yet the somewhat kludgy paths we've had to follow in an effort to implement them has made the matter, I believe, infinitely more complex and controversial than necessary. And the threat of radically upending the long-standing light regulatory foundation of broadband on which massive investment and growth have been built with good effect to implement one set of rules seems distressing. Any shift of that magnitude, I do think, would require Congress's, the people's representatives to weigh in on. A third principle, give regulators the ability and obligation to address changing markets. As we've said, the markets move drastically, and the FCC often has limited ability to make those migrations. Yes, in places they have. There are other instances in which they've not been able to, even when they concede that the fundamental circumstances are changed. Fourth, the law should ensure competitive parity and technical neutrality. There is a hodgepodge of applications of statutes I could point out in which certain rules apply to one sector of a service and not to other sectors. This has just really been an outgrowth of the passage of years and the changing nature of companies. But there are many rules that apply to cable, for example, that don't apply to DBS for no discernible reason. One very valuable thing the committee do is prune through the statute to try to harmonize those differentiated treatments as best as possible. Fifth, the FCC should police markets, not create them. I think this is generally well understood, but there is a role for a cop on the beat. What I don't think there should be is a master chef who believes it's the Commission's objective to make markets or create the conditions and circumstances for them. And finally, the last two, timeliness. If you're working in Moore's Law, you need timely and prompt decisions from the government. Lastly, and most importantly, the law still needs to preserve important societal values and protect consumers from harm, and the FCC and the government will always have a sacred responsibility in that regard. Thank you for your time.
Chairman, thank you. Speaking of cops on the beat, we'll now go to Michael Kopp, served as acting chairman of the Federal Communications Commission from January to June of 2009 and served as a commissioner from 2001 to 2011. Prior to joining the commission, Commissioner Kopp's worked right here on Capitol Hill and the U.S. Department of Commerce. Commissioner Kopp's, Chairman Kopp's, thank you for being with us, and we look forward to your comments to round out our panel.
Thank you, Chairman Walden, Chairman Upton, Ms. Eshoo, Mr. Waxman, Vice Chairman, former Chairman, and all the members of the committee. I'm delighted to be here. We're here today to review whether the Communications Act needs to be updated or otherwise reformed. I've heard some say that simply because the Act is old, it must be obsolete, that no matter how well it has served us, an Act written 18 years ago cannot have relevance in today's altered world. As someone only a little younger than the original Act of 1934, I would raise a caution flag or two. The Declaration of Independence and the Constitution were written long ago, too, yet we still find them critically relevant in our lives. While it is praiseworthy to ponder changes to the law, I would suggest, firstly, that the framework of the current statute remains in many ways strong, and secondly, that the current Act's provisions can still do much to improve our communications landscape, to enlarge economic and social opportunity for all of us, and to nourish the kind of civic dialogue upon which successful self-government inevitably rests. In an ideal world, most of us would welcome an up-to-the-minute rewrite of the law to reflect how we believe it could be improved. The last such revision in 1996 was born of a unique political moment that aligned a sufficient and sundry number of stakeholders across sectors and constituencies who were able to negotiate a compromise statute that, while far from perfect, at least envisioned delivering to every American, no matter who they are, where they live, or the particular circumstances of their individual lives, the most advanced communications technologies and services feasible at reasonable and comparable prices, replete with consumer protections, rights of privacy, assurances of public safety, and utilizing competition to help achieve these goals. Putting the statute to work to deliver these benefits was my mission at the FCC, working with some of the most amazing public servants anywhere. Nowadays, I carry out my public interest mission in the nonprofit sector at Common Cause. In the immediate wake of the new law's passage, the Commission indeed made important strides to carry out these congressional mandates. But alas, things changed. Some of the very interests who helped negotiate the new Communications Act spent more time undermining the statute than implementing it. Such efforts continue to this day, as we saw in yesterday's court decision that, left unaddressed, would seriously jeopardize the future of the open Internet. I appeared in front of this panel many times over the years to voice my dissent on Commission decisions involving the reclassification of communications services, industry consolidation across both our telecom and media sectors, the elimination of policies that had long safeguarded the public interest, and the heavy toll thereby exacted on consumer choices, consumer prices, and slowing the deployment of competitive low-cost, high-speed broadband, this century's most important infrastructure. We can, I know, debate for hours, but a record of these hearings needs to show that many people do not share the easy optimism that others express about the state of America's communications readiness. As you consider legislation in the coming months, some will tell you that America is a veritable broadband wonderland, a triumph of free market entrepreneurship, that puts us at the front of high-tech nations. But there are stubborn facts we must never avoid. The United States, originator of so much of the technology behind the Internet, has fallen from leader to laggard in broadband penetration. According to the OECD, our country is 16th in wired broadband connections per 100 residents. Worse, comparative research shows that Americans are paying more and getting less than wired broadband consumers in competitor countries. The Department of Justice has noted that the local wireless marketplace offers consumers little in the way of choice, even as mobile data plans are saddled with data caps that harm consumption and innovation alike. And once again, for the third time, the FCC found itself unable to certify that we enjoy a competitive wireless marketplace. Surely the time is now for proactive and pro-consumer measures to make quality broadband universally affordable once and for all. While we are not gathered here this morning to rehash those decisions, I do think it is important to understand that many of the faults attributed to the current statute are more the result of powerful industry efforts to undermine it and of Commission decisions that too often aid and abet the effort. So while we open discussions on revising communications law, let us recognize that our present statute has been interpreted and implemented in ways not originally intended, and that many of its constituent parts are still relevant, workable, and consumer-friendly. There is a statute to enforce, and putting that job on hold while we consider changing it is not a good option. Additionally, I think most of us here this morning understand that finding a new correlation of interests that can come together to forge the Communications Act of 2015 or 2020 will be even more challenging than the jockeying that gave birth to the current law. As the world races ahead, we have a duty to make the best possible use of the laws we have in order to achieve the ongoing goals that Congress laid out. These remain powerful interests. A statute that invokes the public interest over 100 times, that highlights the universality of service, competition, and consumer protection, and that underlines the necessity for media that informs communities and engages citizens cannot be all bad. Would I have some preferences for a reworked statute? Of course, although a good part of it would be making sure the Commission and the industry follow through on what is already on the books to foster competition and consumer protection, to deliver on public safety, to preserve privacy in this age of massive intrusion, to avoid never-ending industry consolidation, to put the brakes on gatekeeping in our media, both traditional and new, and to provide the FCC with the resources it needs to discharge its responsibilities. My greatest disappointment at the Commission is that we didn't do enough to encourage media that truly reflects the diversity of our people. Can you believe that today there is no African-American-owned full-power commercial television station anywhere in the land? America is diversity. And if our media fails to represent diversity, diversity of providers and content and viewpoint and ownership, it fails us. The sad plight of communications across our native lands needs to be addressed with renewed urgency and additional resources. Imagine that there are still areas where the majority of first Americans cannot access even plain old telephone service, let alone the kind of high-speed broadband that is the most powerful tool they could have to create opportunity where there is so little opportunity now. I would hope we could find ways to stimulate basic communications research via private-public partnerships. I'm not talking about the next glitzy app, but the basic fundamental research that will determine who wins and loses in the global sweepstakes. I'm for making the Commission more efficient, like doing away with the closed meeting rule that prevents more than 2 commissioners from even talking to one another. And I hope that reform needs to go forward, whether or not it is accompanied by more far-reaching revisions. And I believe that when 3 commissioners have something they want to do at the FCC, that item should go on the agenda. My list could go on, and I welcome the opportunity to discuss such things today. But I always come back to democracy, because that's what concerns me most. Our country's in trouble, reminiscent in many ways of the severity of the economic, global, and social crises it faced in the 1930s, and there are no guaranteed happy outcomes. I just do not see how citizens can be expected to navigate through all these issues and come out with smart decisions for our nation's future when the telecommunications tools we need are not available to all, and in a media environment where community outlets have been short-circuited, investigative journalism hangs by a thread, and wherein we expect some invisible hand to produce those things that the market itself no longer produces and which, in fact, the market alone has never produced. Communications are vital to our economy, but they are the lifeblood the lifeblood of our democracy. They must be available to all, open to all, never the exclusive province of the affluent or the few, always alive to the common good. We shouldn't see our communications world as part telecom, part media, or part traditional media, part new media. We have one communications ecosystem, and our job is to make it work for everyone. And I know of no greater challenge that confronts the Congress, the Commission, or the country. Thank you for holding this hearing today and for inviting me to be a part of it, and I look forward to our discussion.
Chairman Copps, thank you for your thoughtful presentation. We appreciate it. And as you know, our subcommittee has moved forward on some of these initiatives, and we welcome encouragement over on the other side of the building on Sunshine Act and a few other things. So I'd like to open up the questioning process now with a question of Chairman Powell. Since you presided over the Federal Communications proceedings that classified cable and telco delivered broadband services as information services, do you think we would have seen the same level of broadband investment during the past decade had the FCC classified these services as common carrier communications services?
I think, in short, my judgment is no. I think the Internet, at the time that classification decision was made, was more unknown than known. I think it was a period of rampant experimentation. I think the capital required to drive and produce the broadband networks that were not in place needed conditions that allowed them the flexibility to make those choices without the risk that they would be put back into kind of the monopoly era regulatory model. So I think it was an important component to spurring that investment.
Chairman Wiley, does the Federal Communications Commission need to continue to have broad discretion over mergers and acquisitions, or should the Department of Justice antitrust review be enough?
I think there has been duplication from time to time, although I would point out that the Justice Department is looking at antitrust aspects, and the FCC has got a broader public interest standpoint. I think the two agencies need to work together, and I think they have worked together through the years. So I think the process is appropriately developing, but I do worry sometimes that we see great delays in the handling of these consolidations and mergers, which I think is contrary to the best interest of the companies involved, and also contrary, I think, to the public interest and consumers.
And to both Chairman Powell and Chairman Wiley, can the FCC ever really future-proof regulations, given how rapidly technology is changing, and are elements of the Communications Act holding the Commission back from flexibly addressing new technologies?
No, I don't think any agency can future-proof the regular environment, no more than Congress could write a statute that wouldn't, over time, fray in its relevancy in a market that's driven by technological change. I do believe, though, that there are tools to give greater flexibility and not more prescriptive constraints that we have seen in some regulatory vehicles. So, no, they can't future predict. And then I think the other guidance is, I think asking the Commission to engage in anything that requires predictive judgment about future outcomes should be avoided where possible.
Yes, and that's why I suggested in my prepared testimony that we ought to have an opportunity to have a light touch here and have the government have in your statute, have a very flexible, technology-neutral type of approach to this, because it's very hard to predict. The 1996 drafters did not really foresee the development of the Internet to become a universal medium, and I don't think they predicted broadband to be what it is today. So I think you have to step back a little bit and I think allow the technology to develop and to allow innovation and invention to occur without stifling it.
Okay, I'm going to start with Chairman Powell, and then each of you can take this one in the minute and a half I have left. Should the Internet be regulated as a common carrier under Title II?
Well, for me, that's easy, no. I think one of the things I'd like to say about that, though, is that people should fully understand what that means. Even if that were able to give you a better basis for recovering these two components of the rules, it would be the instant application of thousands of pages of decades-old regulations instantly to the Internet where they heretofore have not been, both through on a bipartisan basis. We've had a much more later regulatory environment. The shatter to investment-backed expectations that would result, I think would be exceedingly damaging and more than most people realize.
Chairman Hunt, do you care to comment on that?
Just 2 points. The 1996 Act was shorter than the rules for Little League Baseball, meaning Congress does not necessarily have to write thousands of pages, and in its wisdom, it did not do so in 1996. And that act now has given the FCC the ability to achieve the fundamental goals. As I mentioned earlier, it can choose to use the specific methods that are dictated by the common carrier treatment, but it absolutely does not have to use very many of these methods to accomplish its goals. In fact, the court on page 61 outlined its view of what the FCC should do and said you could treat it as common carrier and have about 30 words that establish the principles. I'm not saying they should do that. I'm saying they can do that.
Do you think they should?
I think what they should do, and I hesitate to say to the current chairman what he ought to do, but since you asked, I think they ought to take a fresh look at all the facts and law as exist right now, and they also ought to be down here listening to you all and having a robust discussion. But the key point is they have the authority.
Got it. Real quickly, the two remaining, because I've gone over my time.
I think
Wiley, and
big,
then we'll conclude.
okay.
No, go ahead.
All right. I think it'd be a big mistake to turn away from in the information service pathway that we've started and go back to common carrier regulation, however that might be defined. I think we want to provide an environment where there is, I think, opportunities for investment and encouraging innovation, allowing businessmen to try to experiment and try to find ways to serve the customer. And I think to go back to a 1934 style common carrier regulation, which was really based on regulating the railroads, I think doesn't make any sense at all.
All right. Mr. Copps, real quick.
My answer is yes, I do. The Court says we have the authority to do that. Whatever we do, we need to do it quickly, promptly, and provide some certainty in the marketplace. I have always stressed the importance of that reclassification. People talk about Section 706. I've always said that there is authority there to do a lot of things. But what we don't need now to get into months of third ways and fourth ways and fifth ways to thread this needle. We need some clarity. Business needs clarity. Right. Consumers need clarity.
Agree on that.
The Commission needs clarity, too. And we have to make sure whatever we do that things like interconnection and those things, consumer protections, are provided.
Appreciate that. I thank the indulgence of the committee. Turn now to the ranking member, Ms. Eshoo, for 5 minutes.
Thank you, Mr. Chairman, and to each one of our distinguished witnesses. What a rich hearing with your testimony. Thank you very, very much. To Chairman Hunt, thank you for your eloquent summation. Without any staff or other counsel to assist you late last night. In your testimony, you discussed the importance of the decision that that this country made to allow Internet service providers full use of the existing telephone network without paying the owners anything. It was a very, very, one of the essential platforms in the success of the Internet. So essentially, we said the incumbents could not be gatekeepers that charge a toll for getting online. In your view, does yesterday's circuit decision reverse that longstanding policy?
No, it doesn't. And I think, Congresswoman, that you've put your finger on the central issue. If I may say, yes, Internet service providers are gatekeepers, and they also are two-sided networks or two-sided gatekeepers, like any gatekeepers. There's somebody on one side and somebody on the other side. And so the situation then is very similar to the credit card industry. So we all have credit cards, and then there's the credit card company, and then on the other side of that, there's the restaurant. And it's very useful for restaurants that we all have credit cards, and it's useful for us that all the restaurants will take them. But it's not so useful if the gatekeeper says, now some of these restaurants, we're not going to allow them to participate in the system. translating that to the present, if the internet service provider were to say, you know, not all the people that are putting the content on their computers, we don't want all of them to be able to have access to all of the users, that's a problem if a gatekeeper behaves that way.
Thank you.
That's the central issue.
Yes, thank you very much. To Chairman Powell, it's wonderful to see you again. As you know, under current law, cable subscribers are required to buy the so-called broadcast basic tier as a condition of getting access to any other cable programming. As retransmission consent fees continue to rise and are inevitably being passed on to consumers in the form of below-the-line fees, I mean, I don't think it's a sustainable business model, most frankly. I just don't think that it can continue to work this way. Do you think that the so-called must-buy requirement makes any sense? Shouldn't consumers have the ability to lower their bills by electing to receive broadcast channels over the air?
I don't. I think it should be an extraordinary circumstance in which the government tells the consumer you have to buy a television package as a prerequisite of buying more of what you want, which is essentially what the rule does. The other grounds on which I think it's fatally flawed is only cable subscribers have that obligation. Dish and direct satellite subscribers do not have that obligation, and they're the second and third largest MVPDs in the United States. Yet a consumer who subscribes to DirecTV does not have to, under a must-buy rule, purchase those programming, but if they switch to Comcast or Time Warner Cable, they do. That's the parity point that I was making, and I think is a perfect place for harmonization.
Thank you very much. Chairman Copps, thank you for being here today. The man with real wisdom, the man that we always count on to place democracy front and center of everything. You know so well that since Citizens United, the last two election cycles that have set records for money spent, including hundreds of millions of dollars from undisclosed sources. The bulk of this so-called dark money spending by outside groups that hide their donors go toward negative TV ads. We all know that. Would you recommend changes to the Communications Act to ensure that voters are informed about who exactly is behind these anonymous TV ads? And is there anything, in your view, that the FCC can do on its own without congressional intervention?
I would recommend enforcing the statute that we already have. And if you take a close look at Section 317, which has to do with sponsorship identification, and which goes back even before the Telecommunications Act of 1934 was written, goes back to 1927, ensuring that listeners and viewers, more recently, know by whom they are trying to be persuaded, whether it's a commercial product or a political product. Those rules were last revisited in a meaningful way by the FCC in the 1960s, which repeated that people have a right to know by whom they are being persuaded. Since then, we have all these new avenues of dark money and super PACs and all of the rest, but we also have the authority, recently reemphasized by the Government Accountability Office, the recommendation that the Commission update those rules and get on with the job. So we can have this kind of information available to consumers so that when you see that negative ad and it says, brought to you by Citizens for Purple Mountain Majesties and Amber Waves of Grain, and it's really a chemical company dumping sludge into the Chesapeake Bay, potential voters, citizens have a right to know that and will know that. That's basic information that you need to have if you're going to have a viable civic dialogue. So this is something the FCC can do. It doesn't await a president making a proposal to do this. It doesn't involve Congress having to pass a law. It involves the Federal Communications Commission doing its job, and it could do this within 90 to 120 days and update the rules to take mind of the new dark money avenues that I was talking about earlier. So this would be a real way to shine a little bit of sunlight on the dark world of TV political advertising.
Thank you very much. And Mr. Wiley, thank you for your wonderful, distinguished public service. I'll submit my questions to you in writing. All right.
All right. Thank you.
Thank you, Mr. Chairman.
Thank you. We'll now turn to the Vice Chair of the full committee, the gentlelady from Tennessee, Ms. Blackburn, for 5 minutes.
Thank you, Mr. Chairman, and thank you all for the time this morning. I want to pick up where the subcommittee chairman left off, talking about the responsibility of the FCC and what it would look like going forward. I think that it's fair to say, and Mr. Powell, I will address this to you because I've heard you say, you know, AOL was on top at one point when you were on top of the game, and where are they now, I think was the comment. But anyway, looking at what the FCC would be, and as we look at the Telecom Act, should we begin to think in terms of the FCC being more as enforcement rather than regulatory in its scope, or in its, really in its scope? Mr. Powell, and then Mr. Wiley, I'd like to hear from you.
I think some aspects of that deserves a fresh examination. You know, the FCC, which I'm a huge supporter of, I've served there with great people, and I think it does an enormously great public service, and there will be functions that are critical to it in spectrum management and many other things. But it is one of the last of the New Deal era agencies that actually has affirmative economic regulatory power. That is, the ability to set the prices, terms, and conditions of market activity, as opposed to having a more significant enforcement, policing, or consumer protection role. Not to say that some of that may or may not still be warranted, but I do think that is a kind of holdover from judgments of different administrative eras, and I would recommend, if you're going to look at it, you should look at the
balance,
the dichotomy and the balance of that role. I do think good leaders, and many of them sitting at this table, have migrated more toward that more defensible role, but many of those provisions still remain. I think they're worthy of second consideration.
Okay. Mr. Wiley?
Yes, I would agree with largely with what Chairman Powell has suggested. I think the Commission does have strong enforcement efforts today, and some would say almost too strong in some instances. But I think, frankly, a lighter touch is the way to go in this area.
Let me ask you this: privacy, data security. It's front page news right now. It's going to be. Do you think that now is the time for the FCC to focus on its core competencies? Or should it move over and look at privacy, data security, or leave that to the FTC? Mr. Wiley? Mr. Wiley?
I didn't hear that. No, I didn't hear it. I'm sorry.
Oh, privacy, data security, leave it to the FTC and the FCC focus on its core mission, or what is your thought on that?
I think so.
You think so?
I would agree with that.
Okay. Mr. Powell, coming back to you, 706. We're hearing a lot about that today. And you may have others who think that, you know, the FCC, that this is an invitation, 706 is an invitation to come in and regulate Internet services. So as you look at 706, do you agree that the provision was intended to give the FCC the ability to forbear from regulations that would stifle broadband investment and innovation?
I agree that the decision certainly gives them the power to forbear, and for many years, many people interpreted 706 as principally deregulatory. It speaks of removing barriers and removing obstacles, less so about introducing them. I certainly was serving at a time where the commissions had held that was not a separate basis of authority, and in fairness to the facts, every commission had so held until recently. So that was the position of the law when I was there, at least. I will say, though, that I think if the commission is going to have a role in broadband, I highly would prefer that be under the construct of the light regulatory information services definitions that reside around 706 than to make a radical transformation to Title II as a regulatory framework for those questions.
Okay. Thank you very much. Mr. Chairman, I will yield back the balance of my time.
The gentlelady yields back, and the chair now recognizes the gentleman from California, the ranking member of the committee on the Democrat side, Mr. Waxman.
Thank you very much, Mr. Chairman. My colleague, Ms. Blackburn, suggested the FCC needs to act more like the Federal Trade Commission. The FTC does important consumer protection work, but I believe we need an agency like the FCC that can write forward-looking rules of the road for industry and consumers. Chairman Hunt and Copps, do you agree with that?
Absolutely, Mr. Waxman. Forward-looking is, here's the best example of a useful forward-looking law. It's in the incentive auction legislation that you passed, where this Congress said, we want the FCC to establish before the auction a generally applicable rule about how much spectrum anybody can buy. That has to be forward-looking. You don't want to go into the auction with your money and not know whether or not you're going to be permitted to win in the keep the license that you thought you were the high bidder on. That has to be forward-looking. So that's a great example of you all asking for a forward-looking rule and really deserving a forward-looking rule.
Mr. Copps?
Absolutely. I concur. We all talk about how rapidly the telecommunications technology and services are changing. The Commission has to be aware of that, have the flexibility to react to that, and certainly to fulfill its responsibilities to look into the future and try to determine how best to fulfill its mission, which includes consumer protection, includes privacy, and includes ubiquity of services.
Mr. Powell, in light of yesterday's decision, the D.C. Circuit recognized the authority granted by Congress to the FCC in the 96 Act. Do you believe that the agency can properly oversee the growth of broadband infrastructure services?
I do. For a matter of record, as chairman of the FCC and the commission that classified broadband the way that it is today, we quite pointedly recognize that the importance of that continuing role to a degree, and we believe that the authority existed within that Title I framework to take care of those circumstances. Whether you agree or disagree, the court certainly validated yesterday, from a judicial standpoint, that Title I and 706 do provide that flexible authority.
And Mr. Wiley, if you agree the FCC has the authority, do you think it ought to use it?
Well, the court said that the Commission could have authority in this area. I would strongly advise, in my own view, the Commission to let the marketplace develop, and if problems do exist, then to step in. There are avenues, if we find blocking, if we find discrimination, there are avenues that can be taken. I think the problem is sometimes we're in search of a problem here that may not exist. I think if you look at all the suggestions of the carriers that have come out of the decision from yesterday, they all want to keep the marketplace open, all want to give consumers access to various kinds of content, and I take them at their word. I think that's going to develop.
Mr. Hunt, if we want to keep the marketplace open, isn't it reasonable to anticipate that some of the players will not want it to be so open if it's to their financial advantage? And shouldn't the FCC play a role to make sure prospectively that we have an open, competitive market with the consumers being in charge?
I completely agree. And if I might, I think it's important, well, let me say this. I have the view that the case and the statute have the following meaning. Section 1706 gives the FCC the authority to accomplish the goals you just stated without also requiring the FCC to make a classification decision. That is to say, it can make a classification decision and act with the authority that would come from that, but it doesn't need to do that in order to pass rules that are authorized under Section 1706, meaning 1706 and the common carrier provision are two independent bases for FCC action. That's why the FCC can choose both or either in order to have a basis for the rulemaking that would accomplish the goals you described.
Didn't the court say that the FCC made the wrong choice and they have two titles they can rely on. You're saying they don't need either title; they can just go ahead and bring about regulation?
Yeah, I think what the court said is if you do choose the information services classification, then you're bound by the restrictions in that. But you don't need to make that choice in order to accomplish the goals that you are desiring, which the court has said that it approves of the goals.
And you don't need to be regulated as a common carrier either.
I beg your pardon?
You don't have to regulate it as a common carrier.
The court has said you could choose that, or you could choose 706, or you could choose both. The only thing you can't do is choose information services classification and pass common carrier-like rules.
I see. Thank you. That's very helpful. Thank you, Mr. Chairman. Yield back my time.
The gentleman yields back, and the chair now recognizes 5 minutes the former chairman of the full committee, the gentleman from Texas, Mr. Barton.
Thank you, Mr. Chairman. I've listened to our testimony and our questions so far, and I'm going to make a brief statement before I ask a question. I was here in 1996, and that act was a philosophical change from where the committee had been and to some extent where the country had been in terms of telecommunications policy. You had a Republican Congress, House and Senate, for the first time in over 50 years, maybe 60 years. You had a Democratic president, Mr. Clinton, who came from a kind of a conservative, pro-business background down in Arkansas. And the former chairman of the committee, Mr. Dingell, and Mr. Waxman, and Mr. Markey, and some of those folks had a very regulatory approach, although not totally so. And in the Telco Act of '96, Mr. Bliley and Mr. Fields, we decided to go with a market approach. And Mr. Copps, as he's pointed out, markets don't always work, but generically, if they're open and transparent, unless there is a natural monopoly, they do give a lot more choice to people. And that's what the Telco Act of '96 did. It rejected the philosophy that the government knows best, that the regulator knows best, that people can't, if they have access to appropriate information, can't make choices that are good choices. And we see reflected today in some of the questions that Mr. Waxman especially just asked, you know, that some of my friends on the Democratic side just don't like a market approach. You know, how dare it be possible that under Title I, informational services, you can have an open, transparent Internet, and you don't need the FCC to tell you what to do. My God, that's scary. We better get that FCC back on the job. They just maybe, you know, if they can't do it under Title II as a common carrier, well, they're just going to have to figure out how to regulate under Title I. Well, you know, if you look at the explosion and what's happened, I mean, I had somebody, a young person, a very young person, about 9 years old, come into my office down in Texas, and apparently did not know there was such a thing as a hardline telephone. Did not know what that was on my desk. This young lady thought a phone was just something you carried around with you. And her parents were very young, and they didn't have hardline phones in their home, and they, you know, her dad worked out of his truck doing stuff and contracting and stuff. She didn't know what it was. So, you know, this thing that Mr. Upton and Mr. Walden are starting to take a real comprehensive review and working with Mr. Waxman and Ms. Eshoo, it's a good thing. But philosophically, I don't want to go back to where I have to depend on the intelligence of Mr. Copps or Mr. Powell or Mr. Hunt or Mr. Wiley and the 3 or 4 other wise people at the FCC to know what's best for me in telecommunications policy. You know, I think if we set the ground rules, and I agree that you have to have a traffic cop, but I don't agree that you got to be so prescriptive that the market just flat gets strangled before it even has a chance to get underway. So my question, and I'll throw it open to the panel, is there still a need for a Title I? I mean, for Title II, for common carrier. In the telecommunication marketplace today, could we deregulate the telephone companies in totality because, you know, there really is no such thing as a natural monopoly anymore?
If we can find a way to assure that some of the qualities that people fought for long and hard in terms of privacy and public safety and consumer protection do not accompany the new tools of broadband and the internet as they accompanied telephone, then I think we're in trouble. I like the market approach too. And it was decided long ago that the telecommunications industry, the media industries, would operate in a capitalistic system, and you don't blame business for trying to seize market control or capture the market or even to have gatekeeping. But we've always, since very early in the last century, had protections against untrammeled building toward monopoly and duopoly. I read the 96 Act, and I wasn't as intimately involved with it as you were, but followed it with some degree of interest, as being somewhat more proactive. I read that act as instructing the Federal Communications Commission to do what it needs to do to encourage bringing the most advanced telecommunications feasible to all of our citizens, no matter where they live, at reasonably comparable prices, reasonably comparable services, allowing them to access media that serves communities and provides information that are necessary to exercise a citizen's responsibilities in a democratic society. So I think, yes, a light touch where possible, but you know, we sit here and talk about, well, we have to do away with these stovepipes and all, and I agree to that with some extent, but we have enshrined that. I mean, if we're going to say we're going to treat a telephone call you make on the internet entirely different than we make a telephone call somewhere else, that's not functional equivalence, or that's not treating technologies alike. So I think
I mean, I know my time is way over, but it's something. It's something to think about, because we've got a real chance in the rest of this Congress and the next Congress to build on what we started in '96.
I would just like to say that I agree with much of what you say. I think in a competitive marketplace that we see today, with the kind of IP-centric world, I think economic regulation has to be considered with some skepticism, because if the markets are competitive, if you don't have market failure, then the question is, why should the government be stepping in? Consumer protection, E911, you know, those kinds of things, that's a different story. Right. But we're talking about economic regulation here, and I think it's more questionable. And I certainly wouldn't be thinking about going back to common carrier world in an information services environment. I don't think that makes sense.
Well, thank you. The gentleman's time has expired, and the chair recognizes for 5 minutes the gentleman from Pennsylvania, Mr. Doyle.
Thank you, Mr. Chairman. Once again, thank you to our witnesses for your testimony today. We've talked a lot about net neutrality in the court decision, so I'd like to maybe go to a couple different topics and ask Chairman Hunt and Chairman Copps about special access. How can the FCC enhance competition in the special access marketplace? And is new statutory authority necessary, or do you think the Commission has the sufficient authority to ensure that the markets are competitive?
On special access, I think what needs to happen, yes, I think the Commission has the authorities for the FCC to make up its mind. I was before this committee, and I think you were here too, and perhaps it was Mr. Markey or somebody who asked us all back in 2007 to sign a letter saying we would have this problem resolved by September, and we all said, whoopee, let's do that. And it hasn't been done yet. All these 7 years have gone by. Enormous amounts of money are at stake here. The ability of competitors to enter the business and to compete is at stake here. I am pleased at some signs now that the FCC is beginning to move, and I want to especially commend you because I know you were a big proponent of getting this data collection process going, and that's the prerequisite of doing something final on this. The Commission also has to look at allegations of anti-competitive practices and special access, such things as loyalty mandates and excessive early termination and shortfall penalties. But getting this right is important, and each year that goes on is billions of dollars going to maybe where they should go or maybe where they shouldn't be going.
Thank you. Commissioner Hunt.
I echo Commissioner Kopps's remarks and would just add this is another example of a very useful forward-looking rule. Or to put it another way, we could all use a forward-looking rule on this topic.
Thank you. Yes, and Commissioner Kopps, we have been waiting years and years and years, and I hope before my tenure in Congress is over that we'll see the FCC do something on special access. And I intend to be here a little bit longer. Commissioner Kopps, the FCC recently closed a very successful low-power FM application process and is currently considering thousands of LPFM applications. And I want to personally thank you for your efforts in that regards and ask you what other opportunities you see for the FCC to further empower communities in innovative ways.
Well, first of all, I want to thank you because without you and the leadership of your colleagues here, this would not have happened. We wouldn't have had that window. First one open since 2000, and it's a window of enormous potential. So, number one, we want that to move forward with all dispatch and maybe go from 800 low-power stations to maybe thousands of them. Going beyond that, though, we just have to look at whatever kind of options we can think of to encourage community radio, to revivify the PEG channels and make sure that they're not just cast aside as some of the big companies seem to want to do. Look at new models for non-commercial media, non-profit media, and that applies not just to media companies but to telecom companies, newspapers, and so many other things. And there's a lot of potential here in a market that doesn't seem to be able to provide all the tools that we need for media and for news, for nonprofit media to step in. But the IRS is dragging its feet on making a lot of these determinations that it should be making. So low power, yes, looking at channels 5 and 6. There are all sorts of options out there. Put some special emphasis on using community radio and diversity of communities and native lands. It's just a field that's rife with potential if we can just step up to the plate and realize our responsibility to do it.
Thank you. Gentlemen, thank you for your insight today. We appreciate it here on the committee. And I'll yield back, Mr. Chairman.
Thank you very much. The gentleman yields back the balance of his time, and the chair now recognizes himself for 5 minutes. And Mr. Powell, thanks again for you being here today. And if I could just start with some questions to you.
Yes, sir.
Yeah, it's kind of interesting because I'm reviewing your testimony and also Mr. Wiley's. You both used very similar language in spots. And in your opening statement, you said that this market requires a greater degree of business flexibility, fewer prescriptive rules, and an assurance that any government involvement is applied on a technology-neutral basis and creates a better investment climate. And I also saw that Mr. Wiley also had said in his testimony about the government can't keep up and there's a need for flexibility and technology-neutral framework in his testimony. So very, very similar language. But in your testimony, when you go through it, I found it interesting because when you go through your 7 points, and for simplicity, And one of the things that you bring out, because you also are talking about that flexibility and also having a better business climate, you state in your testimony that since 1996, we've seen $1 trillion invested in Internet infrastructure. And then you also laid out the simplicity that has to be there. But also in that simplicity, you said that practicing simplicity can be scary.
Yeah.
And it takes courage to discard old ideas and rules that are no longer needed. Could you give a couple of examples of those?
Yeah, it's a great challenging question. I think I might actually go back to some of what Mr. Barton was talking about. If you think about what are the wisest things that was done in the 1996 Act, it has nothing to do with the individual rules. It was the fundamental judgment that the government rejected the natural monopoly thesis and believed instead that competition was the more fruitful approach. But common carriage law inherently is about a government-sanctioned monopoly. It's essentially the queen of the realm who grants an exclusive license to a ferry boat captain to go across the river, and in exchange for all the privileges of that monopoly, they agree to be bound to serve all the citizens in a non-discriminatory way and other things that the sovereign wishes to have as part of that exclusive benefit. Mutual in some regards. The monopolist gets the exclusive profits and the realm gets the benefits of serving all the citizens. In some ways in 1996, the government sued for divorce from companies through the notion of an exclusive monopoly and instead said, go compete. Raise your own capital, no guaranteed return on investment, no guaranteed success, but yet the lingering notions of common carriage, which are still in the statute, and by the way, still being raised in the context of the net neutrality debate, still hover around our regulatory questions. To me, whether the country comes to some committed conclusion that even with its challenges and the need for oversight, that we're really about competition and are ready to truly let go of common carriage is a great example, a fundamental one, of how to make that decision.
Thank you. And let me follow up another question. And when you're looking at assessing the competition in the communications industry, do you think an update of the Communications Act should modify how the FCC currently conducts its competitive analysis?
I think so, only because I think there is some ambiguity there that when managed in responsible hands works fine. At times it doesn't. I am worried about the FCC merger review process in part because it professes to do a competitive analysis following essentially antitrust guidelines administered by other departments, but under the public interest standard, which I do think is valuable, it turns into a competition of conditions. And as an antitrust lawyer, I used to believe at the FCC, if they're doing something bad, shoot them. If they're not, don't let them cure harm by how many good jelly beans you can put on the scale and to make the thing go away. And then by doing it in a way that it extracts these concessions as a voluntary proffer, you make sure that the case can't be appealed to the courts because you no longer have standing. I think insulating the review process from judicial review through the conditioning mechanism and allowing the commissioning mechanism to be a vehicle by which the Commission can legislate beyond its authority, can get companies to do things in the context of that proceeding it couldn't pass laws about, borders on kind of administrative improbability. So does that happen every time? No. Do I think it happens sometimes? Yes, and I think Congress should at least examine the review process and see if whether better controls could be in place.
Thank you very much. And I see my time has expired. And the chair now recognizes for 5 minutes the gentle lady from California, Ms. Matsui.
Thank you, Mr. Chairman, and I want to thank all of the former chairmen for being here. This has been really an interesting, informative discussion. Under Section 254, carriers have certain obligations to provide universal access. In the D.C. Circuit's decision yesterday, the court made clear the FCC has a similar charge under 706 to ensure that all Americans have access to broadband and that the FCC has authority over broadband providers to meet that mandate from Congress. I have two questions for all the chairmen relating to the court's decision yesterday. The first, do you agree the FCC should and must promote universal access to broadband for all Americans? Mr. Wiley?
Yes, I would agree with that.
Yes.
Ms. Powell?
Absolutely. There's no way you can be a functioning member of society without access to this technology.
Okay, then does the court's decision yesterday affirm the FCC's authority to transition the Universal Service Fund to broadband? Chairman Wiley?
Yes, I think the FCC's done a good job in looking at that. I am concerned somewhat with the size and the growth of the Universal Service Fund, and I think the Commission's got to look at the compensate, the pay and the covering that. Some issue that's got to be looked at, I think.
But it's generally yes.
Yes.
Chairman Hunt?
Yes, I would commend Chairman Janikowski for migrating the fund toward broadband, and he did it on a theory of 706. So in that extent, I think the ruling yesterday only strengthens the Commission moving in that direction.
Good.
Yes.
Chairman Copps? That's great. I appreciate your views because I believe that it's one of the potentially biggest unintended consequences avoided by the court's decision, because transitioning USF to broadband is really a critical step toward achieving universal access and adoption in this country. Chairman Hunt, you said that yesterday's circuit decision is a victory for Congress and the smart, flexible approach of the 1996 Telecom Act. How can we continue that success? Are there any unintended consequences we should watch out for as this committee starts the process of updating the Communications Act?
Well, I think as a number of you have mentioned, of course, the FCC on remand needs to commence a new proceeding, which I believe Chairman Wheeler has already said that he intends to do. And naturally, that should be and will be an open proceeding. I'm sure this committee will have an ample opportunity to express its views. I don't myself have the ability to forecast where that will come out or should come out, because I think it's really, really important to examine all the new facts about emerging network architectures and about competition problems on both sides of the two-sided network. I would just say that's why it's so useful that the court has said that the FCC's authority is broad and powerful, because the technologies and the network architectures and the competition problems are constantly changing. And the FCC in rulemaking has the ability to adapt to those changes, sometimes eliminating rules, sometimes writing new rules. So this is a very, very workable process that we have here. And as I said before, congratulations to this committee for the 1996 Act, which did create this legal culture.
Chairman Powell, would you like to comment?
I'm sorry, can you refresh the question?
Well, I'm really...
Sorry.
You know, we, as Chairman Hunt commenting that the court decision he felt was a victory for Congress and for the smart, flexible approach of the 96 Act. Are there any unintended consequences that we should watch out for as we re-examine and update the Communications Act moving forward?
Yeah, I more or less would agree with Chairman Hunt. I mean, I think to the degree that, you know, in some ways I saw a quote the other day that I thought summed it up great, which is, it's not a victory for any side, but it might have been a victory for the debate. And that is that the Commission continues to have a meaningful role in the oversight and protection of broadband without crossing the line into the more dangerous concerns around common carriage. And if that's ultimately the outcome, maybe that's workable. Unintended consequences, I do think the court even struggled with them itself, which is 706 is an extraordinarily broad, unconstrained provision. How it's interpreted and how responsibly it's interpreted and applied, I think is important, because I think, you know, Congress hasn't spoken with much specificity about broadband regulation, and to take a provision as open-ended and vague as 706 and see that as the foundation for everything broadband going forward has potential risks and dangers, but I think that will be worked out over time through its application, through dialogue with Congress.
Well, thank you very much. Chairman Copps.
While I'm pleased that the court recognized the authority of the Commission, I don't know that I'm ready to declare victory yet. If it is a victory for the debate, that's not necessarily a good thing, because we've had so many years of debate while the evolution of the Internet continues and gatekeeping shows the rise of its ugly head. So it's a victory if the Commission reacts and reacts promptly and provides some certainty and some guarantees. But we've lost a couple of years looking for third ways and other ways, and I don't want to lose a couple of more years going down that road.
Well, I think it's an opportunity here.
I was just going to say, I think if it's a victory, I think it's a victory for technical innovation, a victory for investment, and ultimately a victory for the consumer. And I think that's we ought to see how the marketplace develops in this area and see whether problems, as I said earlier, really come about as some people predict.
Well, I think this is an interesting moment in time, and we have to provide a thoughtful way as we move forward. And I appreciate all your comments. Thank you very much, and I yield back.
Gentlelady yields back. Chairman now recognizes gentleman from Illinois, Mr. Shimkus.
Thank you, Mr. Chairman. Welcome, you all. It's good to have you. And I think it'd be safe to say that no one envisioned this world in which we live in technologically. No one envisioned it in '96. So really the basic first question is, in a rewrite for public policy, elected officials, or even folks in a commission to envision what the world will be like 10 years after a rewrite, that's going to be that's impossible to do. Is that, most people view that as correct? No one knew what '96 would come. So that talks about what these basic premises that I enjoy: democracy, freedom, marketplace, capitalism. The one thing that hasn't really been addressed is consumer choice, and how that really does drive innovation and it's that marketplace and I remember going to the Consumer Electronics Show and the MP3 was being unveiled, and I just was amazed at how much capital flowed for just music in this space, in the technology space. And that's the same thing now with internet, broadband, downloads, Pandora, you name it, it's all migrated to that. So we don't ever want to lose the aspect of the power of the individual consumer in this debate versus what some people would say would be the power of a government or regulatory arena or agency. And Mr. Copps, I think that's true for these segments of society that feel they don't have access. I think that you can pull together, based upon technology, ability to get the word out through broadband information, newsletters, and the like. I mean, the technology has allowed us to really, there's really no excuse for people not to have access to information flow today. Even if they go through Universal Service Fund or they go to the library, they get on broadband through what we've been able to do through the E-rates and all that other stuff, which we talked about a lot in your day, Mr. Hunt. So here's the basic question I have, because and a couple of you in your opening statements talk about silos. You were all members of the commission, and you were all chairman, which is a different position than just being a standard commissioner, because you have the responsibility for the whole body of workers within the FCC. So we've got we've got the bureaus and other things other than the bureaus. I only talk about the bureaus, but you go on the website, you see all these other little offices and stuff. Consumer and Government Affairs, Enforcement, International, Media, Public Safety, Wireless, Wireline. So in a rewrite of the '96 Act, should there not be some discussion on how we reform the commission itself based upon what current technology is today? And I think, Mr. Riley, you kind of talked about this a little bit. And just a guess of where it might head in the future. I mean, there's a future look, right, Mr. Copps? There is a future. But how do we reform the FCC itself and start tearing down some of these silos, which some of you have addressed are a problem? And if we can go from left to right, Mr. Riley, if you want to go first, and that'll be the end of my questions.
Yeah, I think what's changed in the Internet world is that you find different parties doing the same kinds of services, providing the same kind of activities that you wouldn't have thought of before. You wouldn't have thought of broadcasters being in the technology end of it, or cable being in the wireline field. But this is happening now, and I think therefore the Commission probably does have to change its internal structure. If you have, in a digital world, if you have functionally equivalent services being provided by different parties, I think they should be regulated in a functionally equivalent way. And that's not the way the Commission has done it through the years. It's not the way they're organized. It's going to take some change.
Thank you. Mr. Hunt?
You know, the French say, well, that works in practice, but, you know, maybe it doesn't really work in theory. And I think it's really, really important to focus on practice. The current structure allows the FCC chair, in what I will definitely describe as an open process, to reorganize the FCC to meet the objectives that are set by any particular Congress in any particular situation. And that's a good thing. So when this Congress had the wisdom to ask the FCC to auction spectrum in 1993, I was allowed, thanks to you, but not because of a statutory mandate, but because of flexibility, I was allowed to create a wireless bureau, which previously did not exist. At any given moment, it's hard to say exactly what the administrative structure ought to be, and I think the current system, which tells the chair, figure it out, tell us what it is, you're held accountable, that's a good system.
I do think form follows function, and I certainly, when I was chairman, we merged a few bureaus. Cable was a separate bureau from broadcasting. Today it's the Media Bureau, and that were changes we made to try to reflect. I think a common principle is organized around the way it's seen through the eyes and the ears of consumers. And, you know, to me at the time, television was television to most Americans, and making sure you had cross-pollination of the bureaucrats, professionals who, the bureaucracy and the professionals who manage that, I thought was important, so that they saw their functions through the same eyes of our constituents. And I think that's one principle you can follow. I do agree with Reed. I think the chairman is also CEO. The statute assigns them that responsibility. I don't think we talk enough about the CEO role and the management of that operation, but I think there's plenty of flexibility to respond to that if it's clear what it is we're trying to execute.
I don't think there's any magic formula. Certainly, there have been times when the stovepipe approach has been too much in presence. I think Michael tried to work against that and go towards a little more holistic type of view. So did Chairman Janikowski. That being said, though, you need the experts in these specific bureaus. There is a specific telecom expertise and a wireline and a wireless and all the details of that and special access and everything else we're talking about. So I think you still have to have those bureaus, but if you can have, I think Chairman Janikowski established a consumer task force whose job it was to go across those agencies and look at whatever those bureaus were doing to assess the impact on consumer well-being. So I think that's a good approach, but it's a management thing and something that I think is the product of good leadership at the Commission and good oversight by the committee.
Mr. Shimka,
we need to move on to Mr. Dingell, I think, for the next 5 minutes. Mr. Chairman.
I want to commend you for this hearing. I think this has been an important hearing, and the events of this week tell us that it's time that the committee is going to have to start looking at what we're going to do about bringing the 96 Act up to date. I've enjoyed comments of my dear friend, Mr. Barton, in announcing my position as being strongly regulatory. Sometimes I have a hard time recognizing my position when it's set forth by other members. In any event, that is not important, but I would just like to remind everybody that this business of the 96 Act started when we began to try and get Judge Green out of the business of regulating the telecommunications industry. It also started when we started trying to get the amount of spectrum that was held out of use by industry and business and government, and get that available to people, and to see to it that we had a fair program for dealing with our legislation and a fair program for dealing with these matters. I'd like to welcome our friends, the chairman here, for their appearance and for their assistance to us and for what it is that they have done with us over the years. If there's an attempt made to update the Communications Act, I will offer my support. Yesterday's court decisions vacating the anti-discrimination and anti-blocking rules in the Federal Communications Commission open Internet order is proof that the Congress needs to bring our communication laws into the 21st century. Only clear direction from Congress will strengthen consumer protections, promote competitions, and give industry and the regulatory certainty it needs to innovate in the future. Now, as we go about this important work, I caution that we do so with great care and on the benefit of a carefully collected and substantial body of evidence. This is going to require rigorous oversight by the committee and considerable work to get the information that we have need of so that we can legislate properly. And I hope that the undertaking will be bipartisan in order so that any final product that we complete here moves through the Senate and to the President's desk for signature. We have to resolve a number of very important, high-line and hard questions to inform our work as we move forward. I respectfully suggest that these questions include, but are not limited to the following. First, how do we improve and protect Americans' access to content while also preserving the ability of private companies to monetize their investments for future growth? Likewise, how do we best foster the ongoing development of future technologies that will assure American leadership in the field of technology and communications? And then we have to decide how we are to promote the more efficient and fair use of value and increasingly scarce commodities like spectrum, which we've not administered too well of late and have administered it oftentimes on the basis of perhaps the amount that we could get for it in money rather than how it would serve the nation to allocate this spectrum. Lastly, we're going to have to decide how we will ensure that the Federal Communications Commission, the National Telecommunications and Information Administration, and other related bodies function smoothly, protect consumers, and promote growth rather than hindering it. Regardless of these answers and the answers to these questions and others, I submit that our work should proceed from the conviction that the public interest is still and always going to remain the central concern that we have with regard to the Communications Act. I have had the good fortune to be one of the authors of almost every major piece of telecommunications legislation passed by the Congress in the past 3 decades, and the public interest is in the heart of each, going back to the 33 and 34 Act. I see no reason why that should be any different this time around. The only issue here worth exploring is what that standard has meant in years past and whether there's any reason to give the Commission different guidance for the future in interpreting it as we address the other questions I've just outlined. Mr. Chairman, I wish you Godspeed in this endeavor, and I offer you and my support. And I'm delighted that the Chairman of the Commission have been here this morning to assist us in beginning this process, which I hope will go forward with reasonable speed with great care and, again, with great attention to the public interest. I thank you all for listening to me.
Chairman Dingell, thank you for your kind comments and your always generous words and willingness to work to improve our communication and other laws. We look forward to working with you. My only disappointment is you did not have a list of yes or no questions for this panel. With that, we'll turn to Mr. Terry from Nebraska, and we look forward to your comments and questions, sir.
Yes, you do. Thank you. And I just, for our esteemed guests here today, I want to follow up on what my friend from California, Ms. Matsui, began, and that's with high-cost areas. But I want to take it from a little bit different angle and get your input. As kind of mentioned here, we've seen a convergence of technologies and services that are all kind of being wrapped into one anymore. And the same as we talked about it in my early days on this committee in voice, and Barton brought that up. Well, now it's in video. And so when we talk about a rural telecom and the internet as a basis of delivering video today, it's kind of making, well, it's altering the way that rural telecoms used to work. And so we have a current legal structure with this QRA and a mindset of on treating rural telecoms like old copper wires, which a lot of them still are using. So I just want to ask your opinions about in reform for or within the FCC, should rural and high-cost areas, so Mr. Copps, it even comes back to inner city, where you have low take but high costs. How do we think about this differently in making sure that if you live in rural America or you're setting up a wind farm where you want to continuously oversee but remotely, thereby requiring broadband for all of that data, do we need to think about things differently than high-cost, rural, high-cost, inner-city? Mr. Wiley, why don't we start with you?
Well, I'm not an expert in the rural telephone area, but I still think there is a concern that's different than in the big cities. And I think, therefore, high-cost funds still are something that have to be part of the whole equation, in my opinion. You know that better than anybody in Nebraska. So I don't have any huge input to you today as to how to change the system.
Yeah. And later, I guess to clarify.
And to be the network for everyone in the country. In rural areas, as I'm sure you know, Congressman, there are many places where the cable broadband penetration is as low as 15 and 20%. Not anything nearly as high as it is in Washington, D.C. or in the suburbs. Now, that's a problem that the FCC really does need to think about in conjunction with the industry that Michael represents so ably. And in particular, not to touch too many other buttons, the recent increases in the prices of the content have a disproportionate impact in rural America, because when those content price increases are passed on by the cable industry, they are taking a lot of money out of the wallets of the people in those areas, and those are the same areas where broadband is expensive. And so as people are paying more for the broadcast content and the cable channel content, they have less available to purchase broadband. This is a problem that is real, existing right now, and it also gives me a chance to pass the solution over to to Chairman Powell.
Congressman, I think you make a couple of important points that we should just put top of mind, which is the challenge of reaching that last 5 to 7% is because under traditional market fundamentals, they're uneconomic. And if they're uneconomic, the only way to cure something is you have to change the economic equation. This is why I've always had no problem understanding and respecting that government has a meaningful and significant role in terms of our ubiquity objectives and universal service, of universality and affordability, to play a role through either the universal service program or any other properly constructed program to try to change the economic equation that attracts the infrastructure that those communities deserve. I think it's a more optimistic scenario in the modern world than it was before, because in the old world, we had a single technology. We tried to string twisted copper wire between two farms 300 miles apart, and that was enormously and hideously expensive. One of the things I think really opens up an opportunity today is because of a common IP platform, we can essentially deliver almost any kind of service over almost any kind of network. So that means that wireless and probably its companion of satellite available services have real hope and promise for rural America. That is, they have very dynamically different cost characteristics. A satellite at 28,000 feet sees rural Nebraska no differently than it sees Manhattan. Wireless has a much lower cost infrastructure for some of those areas. So I think that isn't a complete answer, but putting a lot of energy and investment into how those services will solve those problems is useful. And I think as the chairman of the FCC is moving toward an IP network, common regulatory proceeding, that convergence you're talking about also can get harmonized, and the universal service program get harmonized along with it.
Thank you. Agree.
I have a little different answer. Reasonably comparable services at reasonably comparable prices is the injunction and the charge of the Telecommunications Act. Reforming USF, which the Commission is in the process of doing with lots of wrinkles and problems to work out, no question about that, is certainly an important part of the equation. But anybody who thinks that Universal Service Fund alone is going to bring this country the kind of high-speed, low-cost broadband that we need to have to be competitive in the world arena in the 21st century, I think is not looking at the situation as it is. This has to be an infrastructure mission. Our country's had infrastructure missions before when we came together to build highways and railroads and rural electricity and so on and so forth. And that's what we need now. We are not going to be competitive. We're not going to get out of the holes that we're in unless every citizen in this country has that access. And yes, it's reaching that last 5 to 7%. That's extremely important. But way more than half of our homes don't have the kind of high-speed, low-cost broadband, fiber broadband that we're going to really need to be competitive. So we need to look at that not just as an FCC problem, but as a problem confronting our government and our society, and act upon it and figure out whether we are really serious of being competitive in the global sweepstakes.
Gentleman yields back. Look to the gentleman from New Mexico, Mr. Lujan.
Mr. Chairman, thank you very much. And I must say I was concerned with some of the approach that was being taken in the line of questioning leading up to those last responses to my colleague, where for the first time I heard the importance of rural America. Coming from a western state, from a congressional district that represents 17 of New Mexico's 22 tribes, and the sprawling nature associated with what the West brings us. Many parts of rural America where our food is grown, where energy is generated, critically important to be able to get coverage to these areas. And as I joked with Chairman Wheeler when we had him in front of us a couple of weeks ago, I explained to him that, these last flights home, it's been great to see the TSA debating whether we can make phone calls at 30,000 feet. I know that I have streaming video content at 30,000 feet. I can communicate with my office and anyone else that I so choose to. So if I can communicate with constituents and get the video content that I want at 30,000 feet, why can't I do it on the ground in rural America? The technology is here, and there's no reason that we can't push it out. To the three responses, I just can't say thanks enough for that. Chairman Copps, with the response associated with the very aggressive push to infrastructure investment in America, it's absolutely needed. And we shouldn't forget, especially as we talk about different ideals and philosophies that we have on this committee and even in this Congress and across the country, that it was in many conservative and rural parts of America that benefited from government investment with rural electrification, with major water projects that provide us power now that could be in question because of water flows, a whole other topic of conversation, but nonetheless that we need to make sure that we're addressing. So Chairman Powell, you talked about twisted pairs and what that brought us, decisions that were made as a result of the 96 Act. And looking at Section 706A, I'm not certain what we're arguing about with concerns in that particular area. It's encouraging deployment of reasonable and timely basis on advanced telecom, especially for educational purposes. There may be some concerns with some of my colleagues on price cap regulation, but regulatory for bans, measures that promote competition in local markets. This could be written by any member on this committee, encouraging ideals that I think that we all share. But one thing that hasn't been talked about very much, and even given the fact that there was a huge data breach with Target, 70 million customers that were impacted, is the security of this network. I would hope that, and I'd like to get your opinion, if 706A provides us the necessary standards to be able to bring safeguards, or if you think that that's something that needs to be addressed, and I'd like to invite a comment from each of you. Mr. Hott?
As Chairman Powell said, Section 1706 is very broad, and I think that it is a opportunity and a duty for the FCC to dig into it and to create a appropriate framework with the help of this committee and its counterpart in the Senate. If I might continue your point, your theme of rural America, there are a number of other provisions as well in the 96 Act that the FCC can use to try to achieve the goal of completely widespread broadband even in rural and high-cost areas. And one that I would identify is the current proceeding to reimagine the E-rate. The E-rate, if we went, I just recently met with the chief librarian in Pima County, Arizona, which isn't very far away from you, and you know the geography is not dissimilar. They have a fantastic system of broadband for not just the central library in Tucson, but all the branch libraries. All over this very, very sparsely populated geography. The library is the #1 public internet access point in southern Arizona. Therefore, it's the proper focus of extra E-rate support and the proper focus of the combination of network architectures that might well resemble what Chairman Powell was talking about. We shouldn't decide that part, but we should decide that's a very flexible tool also that can be used to deliver the right participation in the American community to rural America.
Chairman Powell? Congressman, I'd really like to put a punctuation on what you raised because I think it goes to the committee's desire, I hope, to try to harmonize and see the communication landscape as a single ecosystem. All the wonderful benefits we're bragging and celebrating are continuously and daily at risk. I think cyber threat, data retention, breach are all issues that are the Achilles heel of all the promise of the network that we're celebrating. But they require very complex solutions that look through an entire ecosystem. 706 is not particularly up to that job. Why? Even for no other reason that you can't have a discussion without software involved. The cybersecurity question on a global economic ecosystem basis means a conversation with every element of that massive connective chain, and that is the web companies, the infrastructure companies, wireless companies, content companies. There's just no way, in my opinion, even with its breadth, that one could look hopefully to that as the single point of authority to make the most meaningful impact on this issue, mostly because 50% of that ecosystem aren't even implicated by that provision.
I hope 706 is up to the job. I think it does confer a lot of authority, but I don't want this to become just the solution du jour, and we talk about 706 for the next 2 years, and then another court somewhere strikes that down or whatever. I do want to highlight one thing that you mentioned in terms of getting broadband out, and I commend you for your interest in your work with Native lands and Native Americans. And one area where I think maybe a rewrite would help would be to more formally institutionalize, put some flesh on the bones of the trust relationship and the consultative mechanisms that we have between the Commission and Native Americans. It's working better than it has. I think there has been more emphasis in recent years. Obviously, back in Chairman Kennard's time, was not here today. There was interest in moving us forward and getting us into a new trust relationship. But that's 13 or 14 years ago, and the situation, as you point out, is so dire when one member of a tribe can't call somebody else, but you can make the call from 30,000 feet. That's something wrong there. But that might be a concrete area where the Commission can actually, or where the Congress can actually lend a hand.
Appreciate that. Gentleman's time's expired. We'll now go to the gentleman from New Jersey, Mr. Lance, for 5 minutes.
Thank you, Mr. Chairman, and to the distinguished panel. This is among the most interesting hearings in which I have ever participated, and it's my honor to be able to meet all of you. I gather there is a consensus from the distinguished panel that the 1996 legislation needs, to some extent, statutory update and revision. Is that accurate from the panel?
I would agree.
I don't agree.
Chairman Hunt, if you would indicate why you do not agree there needs to be statutory update.
I think that the D.C. Circuit has made it very clear that the 96 Act has given the authority to the FCC to address all the economic and social problems that this committee in recent years and in past years has asked the FCC to address.
Other distinguished members?
I basically concur and agree with what Chairman Hunt has said. Sure, it's always nice to have some additional clarity, but time is of the essence here. We have a statute that I think can deliver on a lot of the things that need to be delivered, and we should be about that job. It's so difficult to see the correlation of forces coming together to give birth to an act after what we went through in 1996, and I don't think it's going to be any easier in 2014 to do that than it was 18 years ago.
Chairman Powell?
I think by any measure, a deliberative process in the legislature would take a meaningful number of years, as Chairman Walden himself has recognized in setting out a multi-year process. I do think there are sufficient conditions to justify the institution of that kind of examination over that period of time, because I think the market is radically different, and the relevancy of law as applied to reality should be a core principle of governance.
Thank you.
I think the very fact that you didn't have the Internet really developed, you didn't have broadband, you didn't have all the technological changes that have occurred since 1996, really gives, I think, substance to taking another look. And I think that gives Congress an opportunity, I think, to perhaps make some suggestions to the regulatory body that I think would be very helpful.
Thank you, Chairman Wiley. Am I accurate? I've not read the decision. I have reviewed its consequences, but I've not read it, and I certainly will read yesterday's decision. Am I accurate that the FCC decided in 2004 that Internet access services would not be classified as telecommunications services? Is that true, Chairman Powell?
Yes, sir, that's correct.
And if that decision were to be revisited, that could be revisited by the administrative agency. Is that accurate as to how it could proceed?
It is accurate. It could.
And if there were to be a revisiting of the 2004 decision that this is not classified as telecommunications services, then there would have to be an extensive a period of review, and there would have to be some sort of high-level determination as to why a different decision were to be made. Is that the way it would work?
Yes, under administrative law, even with deference, the agency has to provide a reasoned explanation for its change in policy. It would require a notice and comment proceeding, which is open.
Yes.
And I wouldn't, the suggestion's been made that somehow that would lead to instant clarity. It would lead to another 3 to 4 year period of conflict and litigation.
And litigation. And Chairman Coffs?
But I would just say I don't think it would take forever to compile that record. I and a lot of other people I know would be happy to contribute to the rationale for that sort of action. So it's not really starting at on a tabula rasa. I think a lot of that information is out there. It was just a route not taken, and now we need to go back and look at it.
And the FCC's reclassification would be considered arbitrary and capricious unless there were a period of comment and refreshing the record and some sort of heightened standard. Is that accurate legally?
Yes, sir. They have to follow the Administrative Procedure Act obligations.
And I'm certain they would.
I would presume that would be the case. And finally, the decision yesterday possibly could be appealed to the Supreme Court, but it's not clear whether or not either side is likely to do that.
That's correct.
Thank you very much. My time has expired, Mr. Chairman.
Thank you, gentlemen. Now turn to Mr. Long from Missouri. I think our last member to ask questions. Please go ahead.
Thank you, Chairman. And Chairman Hunt, last night you said that you spent quite a bit of time trying to go through the court ruling of yesterday, and most of the congressmen were home trying to read through a 1,562-page bill that we're going to be voting on this afternoon. So I've ordered my staff to bring a copy of that to you, and if you could peruse that over if you can peruse that over your lunch hour and kind of decipher it for me, I would appreciate it. Earlier in your testimony, Chairman Hunt, you said that, and I didn't understand your point, I don't think, concerning the auction. You said, if I remember right, that we need a cap so people know what they're buying. Can you kind of tell me what you were? In full disclosure, I come from a 30-year career as an auctioneer before I came to Congress a few years ago, so I've got a lot of interest in how an auction operates and try and make it operate the best it can for the public and the taxpayers.
I remember very well that in our first auction, we had Senator Burns, who had a
Conrad Burns, you bet,
come and conduct the very first
He is
auction.
from Missouri. Now, he's served from Montana, but he's originally from Missouri, so that's two of us.
He did claim that particular heritage, and he did a great job. And if I would recommend to Chairman Wheeler that he should come and ask you to conduct the next auction.
I'm not worried about conducting as much as I am how it's put together, and that's what I've been trying to drill down on. But what was your comment? I didn't understand. You said that we need a cap so people know what they're buying. What exactly did you mean?
So in any auction, when folks come in, you want the high bidder to be able to walk away with whatever was auctioned. And the way to do that, I believe, is to make sure that everybody bidding in that auction knows the following. What are the rules about how much you can buy? It doesn't have to be a cap. It could be, some people think it should be an aggregation level. There's many different ways to define it, but people ought to know as they're about to take the money out of the wallet, as they're about to raise the hand and say that they're putting in the high bid, they ought to know that they can walk away with whatever they can buy, instead of having to have another proceeding where they ask the FCC or the Department of Justice later, am I permitted to walk away with this because I don't know whether or not I've violated any of your aggregation rules. So this Congress, in the incentive auction rule, did say that the FCC should create a generally applicable aggregation rule, and I think that was a very wise thing to do. That way everybody going into the auction can estimate in advance whether or not what they buy is what they bid on and win on is what they can walk away with.
Okay, talking to the interested parties that are interested in buying this spectrum, they have told me, and this is probably a topic for another day, but they said if they can buy A, B, and C spectrum, then maybe they want to buy LMNOP later in the auction. If they can't buy A, B, and C, LMNOP doesn't. If they can't buy that too, then the first three things that they bought. So it's a very confusing situation. So any of you have any staff or anybody you want to get with my staff that we can talk about, kind of sort that out, I'd appreciate it. I want to move to Chairman Wiley for a minute. If you turn on the TV at night, the only reason it's not 100% phone company ads and cellular companies and things is because it's interspersed with the auto insurance ads. So there would be more. So it seems like there's quite a bit of competition out there now. And as far as the auction that I was talking about with Chairman Hunt, the wireless market, I think, appears to be extremely competitive. And you do have larger companies, AT&T, Verizon, T-Mobile, Sprint. And given that, doesn't it make sense that the FCC, why will they, should they not, they shouldn't handicap bidders, should they, to get the most money for the taxpayers and have the best auction they can? Where some people are wanting to limit who can buy what. Can you kind of walk me through that?
Well, my view is that the auction ought to be available, open to all. I think if Congress really wants to see the maximum amount of revenue derived in order to support the public safety network we're going to have, to pay the broadcasters, it's a very complex process. And I am concerned about the fact that if we start to begin to limit people in this, that you're going to find you're going to have less revenue than might be otherwise anticipated. I think a free auction ought to be open to all.
When people would attend my auction, I was always interested in having the most people there and have them spend the most money that they could. And if they didn't want to bid, I would bid for them. I'd tell them just to hold their hand up in the air, and when they'd paid enough, I'd tell them to take it down. So, that, Mr. Chairman, I yield back.
Quite an auction.
I want to thank our distinguished panel of witnesses, both for your prior government service and your continuing involvement and interest in public policy to assist us in our mission and goals at updating the Communications Act. I draw attention to those who are observing our hearing. They can go to our hashtag and at Comms Act Update. I think it's right in front here. And give us your information. A lot of people have been doing that during the hearing. We appreciate that. Another reflection of how technology is changing the world, and we need to keep up with it. So thank you for your participation. Our subcommittee stands adjourned.
Bravo.